स्टार्ट करें।
आइए हमको फाइल करना है, इसलिए हम 2 सप्ताह का। दूसरी चीज़ ये है कि कॉम्बिनेशन ऑफ डिले के लिए ये जितना भी केसेस है वो एक ही फैमिली का है, एक ही परिवार के सदस्य है उसमें। तो हम सिर्फ इतना ही रिक्वेस्ट करते हैं कि एक ही
ऐसा क्यों नहीं, ऐसा नहीं हो सकता, ऐसा नहीं हो सकता। आप लोग को पिटीशन फॉर कॉन्ट्रडिक्शन ऑफ डिले फाइल करने में भी परेशानी है, इसका तो मेरे पास कोई जवाब ही नहीं बचा।
परेशानी नहीं,
फिर क्या परेशानी है?
परेशानी नहीं, मैंने एक लीड केस करके हम लोग उसमें ही डाल।
ऐसा नहीं हो सकता। Not happen like this. आपको क्या क्या इसमें आइए फाइल करना है?
कॉन्बिनेशन ऑफ डिले के लिए,
और
दूसरा है एग्जेम्पशन ऑफ फाइलिंग ऑफ सर्टिफाइड कॉपी। सब में सर्टिफाइड, एक में सर्टिफाइड लीड केस जो उसमें सर्टिफाइड कॉपी हो
तो आपको ओरल सबमिशन में भी होगा, लेकिन आप वेट इज द अदर साइड।
उसके बाद एक
अदर साइड कहाँ है? यूनियन ऑफ इंडिया है इसमें, अदर साइड कौन है? एनटीपीसी। वेयर इज ही? अभी उनका कोर्ट का टाइम शुरू नहीं हुआ क्या? ऑन द वे टू हाई कोर्ट। So ask him that how many minutes should we wait? Ask him. He has not come to the court so far. Yes? कोर्ट में नहीं आए हैं आज सुबह 10:30 बजे से। किसमें सर्टिफाइड कॉपी? बाकी में अवार्ड का तो सर्टिफाइड कॉपी सब में फाइल करना होगा ना? सब में कर दीजिए।
तीसरा एक एग्जाम्पशन से आ रहे थे कि जो कोर्ट फी है वो हम लोग या तो
बहुत नॉमिनल कोर्ट फीस है, इसमें कोर्ट फीस ज़्यादा नहीं है।
हम लोग क्लेम ही वहाँ ही क्लेम 50,000 का हुआ था। हम चाहते हैं कि वो क्लेम को रिड्यूस करते हैं। क्लेम एक्चुअली वो सस्टेनेबल था नहीं 50,000। तो जो कोर्ट का फाइंडिंग्स आया है उसके हिसाब से हम अपना क्लेम बनाना चाहते हैं।
मतलब
करेक्ट करके हम
क्या चीज़ करेक्ट करेंगे?
क्लेम अमाउंट जो है वो 50,000 की जगह हम लोग उसको रिड्यूस ताकि कोर्ट भी हमारा, उनके सब एकदम गरीब फैमिली से है, ज़्यादा पैसा। दूसरा एक और हुआ था, तो एक
आप लोग खाली टाइम लेने का स्कीम बनाते हैं।
नहीं, कोई टाइम नहीं, 2 सप्ताह से।
तो क्यों नहीं किया अभी तक? लिमिटेशन पिटीशन क्यों नहीं फाइल किए?
2 सप्ताह।
एग्जेम्पशन पिटीशन क्यों नहीं फाइल किए? ये कोर्ट फीस वाला पिटीशन क्यों नहीं फाइल किए?
1 सप्ताह लेते हैं।
क्या 1 हफ्ता टाइम लेते? क्यों नहीं किया अभी तक? I want to know why have you not done so far?
अभी तो स्टाफ रिपोर्टिंग के बाद ही कुछ कर सकते।
आपको नहीं पता लिमिटेशन पिटीशन फाइल करना होता है?
और ये वही बताते हैं कि हम लोग,
ये वकील साहब का काम है कि स्टैम्प रिपोर्टर का काम है? क्लरिकल वर्क है क्या? हाउ मच इज द लिमिटेशन?
1 सप्ताह का टाइम देंगे हम, 1 सप्ताह का। मैंने भी कर नेक्स्ट वीक को रख दिया।
कोई इंटरेस्ट ही नहीं है केस करने के लिए, तो हम लोग अपना सच
ना हम पूरा नेक्स्ट वीक को
आपका वकालतनामा भी डिफेक्टिव है कई केसेस में। जी आपका होमवर्क हम करके लेके आए, ये सारे केसेस का डिफेक्ट है। और बताइए और क्या मदद करें हम आपको? ये सारे केसेस का डिफेक्ट है इसमें, सब्जेक्ट टू वेरिफिकेशन बाय हम लोग को जितना समझ आया हम लोग का।
अमाउंट है वो तो उसको
तो वकालतनामा कैसे इग्नोर करेंगे? वकालतनामा का डिफेक्ट हम इग्नोर नहीं करेंगे।
कुमार उठा करके साइन किया, वो कुमार नहीं है उसमें।
तो हम फ्रेश वकालतनामा फाइल करना पड़ेगा। वकालतनामे में कटिंग भी नहीं करनी देंगे। We will not permit any cutting in वकालतनामा। अगर एफिडेविट में जो आप लोग कटिंग कर लेते हैं ना अपने मन से, वो भी नहीं परमिशन
वो तो एक बार वकालतनामा जिस हिसाब से वो एक्सेप्ट कर लिया।
इनको दिखा दीजिए लिस्ट। You just tell us seeking exemption from filing certified copy in all the cases.
Yes.
Can it be allowed by oral submission?
No. It cannot. It has to be. We also filed one IA for that exemption.
आपने एक सिंगल आईए फाइल किया
Filed
for all the cases.
No. I filed in all cases that IA. Because
Some
that required an exemption, I filed in all cases that IA for exempting me from filing.
आईए पर एग्जेम्पशन फाइल करना होगा। कोर्ट फीस के एग्जेम्पशन के लिए भी आपको आईए फाइल करना पड़ेगा, लेकिन अल्टीमेटली तो देना ही पड़ता है।
कोर्ट
जब
फी
भी
तो
आपको
फाइनल डिग्री जब बनेगा तो उस समय पे रिकवरी होगा।
रिकवरी होगा। इस तरह का हम लोग इस तरह का मैटर,
लेकिन इंडिविजुअल मैटर पे तो कोर्ट फी बहुत हाई तो नहीं होगा
ना, बहुत छोटा सा अमाउंट है।
तो वो थोड़ी प्रॉपर थोड़ी है। डिक्लेरेशन प्रॉपर कर लेंगे तो फिर इतने झांसा से मिलेगा पैसा ही।
ठीक है। अरे ये एनटीपीसी है, हम गरीब आदमी बस इतने ही।
हम भी इन लोग के
तो
चक्कर
आप
में
कोर्ट
गरीब।
फीस भी नहीं देना चाहते हैं। लिटिगेंट ने आपको कोर्ट फीस नहीं दिया क्या?
अब वकील रख रहे हैं इसीलिए झांसा से नहीं ला रहे हैं। एडवोकेट्स इंगेज्ड।
आप बताइए। कोर्ट फीस हैज नॉट बीन पेड टू यू एज अ काउंसिल।
नहीं फाइलिंग चार्ज हम लोग लेते ही हैं। ये है सर।
आपके स्टेटमेंट में रहना चाहिए that you have not paid the court fees to the council also and you are not able to pay। तभी हम अलाउ करेंगे। नहीं तो इतना छोटा अमाउंट के लिए क्यों एग्जेम्पशन देंगे?
और उसका
इतना
फिर
छोटा अमाउंट है। आपका यूजर्स सी हाउ मच इज दिस?
डिफरेंस अमाउंट पे ही जाएगा। जो मिल गया उसमें थोड़ी जाएगा। डिफरेंस
आप ही
अमाउंट पे
बताइए 8000 कुछ रुपया में क्या हम लोग
हाँ तो हर पार्टी डिफरेंट है। एक फैमिली का
नहीं, एक फैमिली है।
एवरीबॉडी इज गेटिंग डिफरेंट
फैमिली एक
कंपनसेशन
है, लेकिन अलग हर एक को अलग कॉम्पनसेशन मिल रहा है ना।
थोड़ा सा
और लाखों में मिल रहा है।
अगर मिल जाता तब तो दे ही देते, अभी मिला नहीं।
कैसे हम लोग तो डिपॉजिट कर दिए हैं जो है। इसी हम लोग वहाँ जो अमाउंट एसेस हुआ था तो इन प्रोसेस हम लोगों ने अंडर प्रोटेस्ट वहाँ जमा किया। नहीं हम प्रोटेस्ट बिकॉज़ वी हैव चैलेंज दैट अमाउंट सो वी हैव डिपॉजिटेड। और
हम नहीं जानते हैं, इनको कोई इंटरेस्ट ही नहीं है अपना केस करने में। कब रखना बताइए?
एक सप्ताह बाद रखें।
फाइलिंग नंबर ए पे 14997 of 2025 with 59 analogous cases।
that is on daily list. Our yes,
ये वाला 59 analogous।
These are 59 analogous.
In the supplementary causes।
Yes, for there it is in
Yes.
there. And ours is in
The
daily.
counsel for the appellant submits that the matter be posted next week. In the meantime, they shall either remove the surviving defects or file appropriate petition in connection with one or the other defect। कॉमेंट मत दीजिएगा, हम नहीं करेंगे। I will not permit that।
तब 2 weeks
आपकी मर्जी है, आप कितना टाइम लीजिए। At his request, post on 28th, temporary order करेंगे। 2 हफ्ता टाइम दी, temporary।
सर्वाइविंग डिफेक्ट्स का कुछ डिफेक्ट नहीं रिमूव होने लगे।
ये कौन सा रिमूव होने लायक है?
ये
आपके पास लिस्ट है, बताइए कौन सा डिफेक्ट रिमूव होने लायक है? In case regarding defect of वकालतनामा, fresh वकालतनामा is required।
एक लिस्ट भी बना दिए थे हम लोग करस्पॉन्डिंग केसेस जो इनका मेरा है, चार्ट बना दिया।
अच्छा, इनके वाले केस में क्या बोलना है आपको? इनका भी बैच है, आप सब में अपीयर हो चुके हैं,
इनका तो आज ऑर्गेनाइजेशन
Date?
डिले का है।
तो क्या करें
डिले
सही
का अगर आपको कोई आ सकता है।
चल लाइक सब में सेम है।
से
I think 22 from days.
कितना डेज डेज कितना है?
30 के राउंड है, 25 26 30 टाइप में है।
ओके, एक का ऑर्डर करते हैं, बाकी सब में अलग अलग ऑर्डर कर दीजिएगा, ठीक है? देखिए एक फाइलिंग नंबर FA2305 और 2025 इसका नंबर पड़ गया ना। FA नंबर 52 और 26 विद आगे नंबर 2735 of 2025.
We have said 13 days.
This petition has been filed. Seeking condonation of delay
As per us, it is 1-3 days.
of 24 days, start के 24 days. Of 24 days in filing the appeal. The counsel for the appellant has referred to paragraph 5 of the interlocutory application. He has submitted that the claimants have also filed separate appeals, which is pending before this court. The learned counsel submits that the delay will continue, the case be admitted, and the records be called for from the concerned court. In the meantime, the claimants' cases may also be tagged along with this batch of appeal. Counsel for the claimant has no serious objection so far as the prayer for condonation of delay is concerned. After hearing the counsel for the parties and being satisfied with the cause shown, the IE number 2735 of 25 seeking condonation of delay is hereby allowed. Admit, call for records from the concerned court upon deposit of special messenger cost. Since एक ही set record होगा ना सबका?
एक ही record है।
At this, the learned counsel for the appellant has submitted that one set of special messenger cost should be sufficient, as the impugned judgment is the common judgment.
Rising out of same
ही record लगेगा क्या?
same ही record है। हालांकि LA केस नंबर अलग अलग है, जजमेंट सेम है, लेकिन LA केस सब डिफरेंट है। और if your edition will come to page 36 onwards, this is edition will find different LA case numbers, but they are all tagged together, so record would have been.
They are all since all the matters were tagged, and therefore one set of special messenger should be sufficient. Considering the sanctions, one set of special messenger cost should be sufficient for the purposes of calling the records through special messenger. One set of special messenger costs be filed within a period of 1 week. ये आपका हो गया काम?
Daily list में था ये 50
सब
and
आगे
my matter was originally fixed for 28th of January.
Pose this case on.
So it was originally fixed. This case is coming on 28th January.
Okay, it's supposed to be.
Because of their defect, it was listed for today.
Pose this case on 28th of January. इनका तो कोई नहीं आपका 28 को.
हम 28 को भी लगा।
उस दिन भी आपका भी रहेगा 28 को. Let this order be communicated to the concerned court immediately. आपको एक हफ्ता की बजाय अब थोड़ा कम टाइम दीजिए. कहाँ का है ये? हजारीबाग का है. Within 3 days आप special messenger cost
We will deposit tomorrow. But only thing is that if your editions order reaches there, because
नहीं
they
नहीं, of
don't
course
take-
it will.
So tomorrow itself will.
एक चीज और हम बताना चाह रहे हैं, इनका रिकॉर्ड दिखाइए. आपका ये सूट वैल्यूएशन का जो एरर है ना, इसमें एक चीज पे ध्यान दीजिएगा. आप अवार्ड निकालिए एक भी. ये वाला केस का अवार्ड निकालिए. FA फाइलिंग नंबर 14997 of 25. कोई भी केस का अवार्ड निकालिए. पेज 78 में जो सेकंड पेज है अवार्ड का, निकालिए. ऊपर दिख रहा है ना 11,000. ठीक है, ये है आपका awarded amount. 41,000 आपका awarded amount नहीं है और आपने अपने मेमो फी में क्या लिखा है 41,000. ये एरर है, वो उन लोगों से बुला के पूछे थे, उन्होंने यही बताया. हम बोले कि क्या एरर है, तो बोले कि ये जो अमाउंट इनका पर एकड़ का जो फिक्स हुआ है या जो भी पर कट्ठा या जो भी है,
अब वो गलती से हो गया, उसको करेक्ट.
गलती से नहीं, आपके हर एक केस में यही काम
हाँ,
है.
ये
तो इसीलिए आप उसको अकॉर्डिंगली ही इसको करेक्ट करेंगे और कोर्ट फीस जो है आप इसको अकॉर्डिंगली जमा
पेज
करेंगे.
नंबर 2 जरा लिखो.
क्लेम अमाउंट हम लोग 50,000 लिखे हैं।
वो तो ठीक है, आपने क्लेम अमाउंट
नहीं नहीं, उसको हम लोग जो लोअर कोर्ट का फाइंडिंग्स आया 15,000 का, हम लोग चाहते हैं कि 15,000 क्यों 50,000 देके फिर हम लोग कोर्ट फी में के चक्कर में पड़े.
तो आपको आप अगर 15,000 रुपए कोर्ट फीस देंगे
हाँ,
तो फिर 15,000 से एक्सीड नहीं होगा आपका क्लेम.
नहीं,
फिर हम आप यही मानेंगे कि आपको 15,000 रुपए से ज्यादा नहीं चाहिए.
ना उतना ही आया ही हमारा फाइंडिंग्स भी कोर्ट का लोअर कोर्ट का ही है.
तो फिर आप क्यों अपनी फाइल किए?
11 से 15 मिला, 11 से 15.
आपका क्लेम 15,000 का था.
नहीं,
वहाँ 50,000 वहाँ
नहीं
50,000.
नहीं, इस तरह से नहीं करिए. प्लीज डोंट डू इट दिस वे. आपका जो क्लेम अमाउंट था उसी पर चलेगा. आप अपना अपने मन से आप कुछ
यहाँ
भी
चेंज
कर
कैसे
दीजिए.
होगा? स्कूल वैल्यू वहाँ कुछ रहेगा,
नहीं.
यहाँ कुछ रहेगा.
ऐसा नहीं होगा, इसलिए थोड़ा ठीक से कर लीजिए.
भैया एग्जामिनेशन के लिए फाइल करेंगे, कोर्ट भी बाद में जज का से
आईएल फाइल करिएगा ना आप. एक तो ऑर्डर लगा दीजिएगा उसमें.
और अवार्ड सब अंदर के ओरिजिनल आएगा. मेरे केस में भी सारा अवार्ड
अवार्ड सब आपका सर्टिफाइड कॉपी आएगा. खाली ये इसका आएगा आपके पास.
जजमेंट का.
जजमेंट का.
जजमेंट है बस, अवार्ड तो लगा ही
फाइल होगी. ग्रेट.
हाँ सब. सप्लीमेंट्री में डाल देते हैं 28
जी,
को. ऑल
जी.
दीज केसेस.
I'm in process
ऑल
of
दीज
making short
केसेस आपका भी
synopsis.
और आपका भी.
I'm in process of making that short synopsis.
Yes. हाँ, वो 28 तारीख. प्रिंट्री करने से मुझे परेशानी रहेगा. टैग करते हैं.
Out of 10 mentioned case, item 89, second appeal 16 of 2026.
Sole fundamental substantial question is that both the court below have committed a fundamental error by allowing and decreeing in favor of the plaintiff when the concerned person who has filed the petition or the claim on behalf of the plaintiff, his authority has not been free to prefer that suit. Because he claims to have filed it on the basis of authority letter, authorization. That letter has never been executed.
He was the power of attorney.
That has not been executed. That power of attorney in the list of exhibit that doesn't exist. From the suit judgment, it will be relevant to know.
There is an order of the Supreme Court.
Yes, there is an order of the Supreme Court, because that leading that document in the trial court at a belated stage was objected by us. We succeeded before this honorable court. They went in SLP. The SLP was allowed on the pretext that there is a reference in the verification part, and therefore it is sufficient. They can be led, and it is. The Supreme Court held that the suit has been filed by the authorized representative. So, by that time, the exhibits had not been.
We do not know. There was an objection, and then that objection was ultimately overruled by the Honorable Supreme Court.
But the
So, on the face of that judgment of the Honorable Supreme Court, your objection that he was not the power of attorney holder, etc., has got no relevance.
But unless, to my understanding, unless the document is exhibited, led in evidence, and on that count, I will be relying on two judgments of the Supreme Court.
Was there any issue framed on this point?
228.
That the suit was not maintainable? Did you join issue on this?
Issue number 1 probably covers this aspect.
Let us see the finding with regard to issue number 1 and what was your case before the court.
Issue number 1 decided by the trial court is at page 46. Issue number 1 is the suit maintainable in the present form, that is at running page 35. The issues framed by the trial.
Yes, issue framed.
Well, as the plaintiff got valid cause of action for the suit, is the suit barred by principle of
The
waiver?
power of attorney was examined as a witness.
No. The power of attorney was filed in the year 2011, which was objected, but finally it was never examined. Because that will be para 8 of the trial court judgment, page 35. The exhibits of the plaintiff are indicated. Seven exhibits are there by the plaintiff. Power of attorney or the authority letter is not an exhibit.
The legal notice was issued by whom?
By an advocate.
At whose instance?
It doesn't bear the signature of the party. May I hand over?
PW1 Ramanand Prasad was the power of attorney holder.
As claimed.
He has been examined.
He has been examined, but he has
Power
not.
of attorney holder has been examined.
But he has not proved the
That
power of
is a
attorney.
separate thing. But he has been examined. You
He has
cannot
been
say that he has not been examined. Power of attorney has been examined before.
The witness has been
As a
examined.
witness.
As a
Yes.
witness.
Certainly.
He has not laid in evidence the power of attorney. Right.
Where is the finding with regard to issue number 1?
But by the trial court is at page 46.
Yes, read it please.
While deciding the main issue, this court has already held that defendant was inducted on the premises in suit as per leave and license dated 4/8/1982, only for 2 months on payment of maintenance charges of ₹500 and electric charges of ₹100 and other establishment charges, and the defendant, after expiry of the said specified period from 4/8/82, neither paid the maintenance charges nor vacated the premises, and accordingly the plaintiff issued legal notice dated 19/8/1987 by registered post with AD. Despite the notice, when the defendant neither paid maintenance charges nor vacated the premises in the suit, then the plaintiff has no option but to file the present suit. This court also finds that the defendant violated the terms of leave and license and not paid the maintenance charges to the plaintiff since 1/5/84, and as such he is liable to pay the arrears of maintenance charges and also be liable to vacate the premises in suit. Accordingly, I find that the suit is well maintainable in its present form. The plaintiff got valid cause of action for the present suit, and the suit is not barred by the principles of waiver, estoppel, acquiescence, and limitation. Further, plaintiff is entitled to a degree of eviction as claimed.
This aspect has not been considered.
The exhibit, if I may render photocopy of the certified copy of plaintiff exhibits.
Why do you want to show this?
I'm sorry.
Why do you want to show this?
To indicate that the power of attorney has never been laid in evidence. Or
Has
the
never
authority
been
has
exhibited.
Never claimed. And on this count, there are 2 judgments of the Honorable Supreme Court which I intend to write on. May I tender for this one? But may kindly take 2011 SCC 524. I'm sorry, but I have wrongly given my copy to my lords because I went back.
वन में वापस कर दीजिए। पैरा नंबर
Para number 14. Ma'am.
yes.
In our view, the judgment of the challenge is liable to be set aside because the respondent had not produced any evidence to prove that Sri So-and-so was appointed as a director of the company and a resolution was passed by the board of directors of the company to file a suit against the appellant and they authorized Sri So-and-so to do so. The letter of authority issued by So-and-so, who described himself as the chief executive officer of the company, was nothing but a scrap of paper because no resolution was passed by the board of directors delegating its power to Sri So-and-so to authorize another person to file a suit on behalf of the company. And the other judgment order 2009-10 SEC 601, paragraph 8 and 9.
Yes.
If we interpret the definition of landlord in the act literally, it will result in strange consequences. It will mean that even if the owner who is the natural landlord does not want to evict a tenant, his agent may do so. Surely this is an absurd situation. It is well established that if a literal interpretation leads to absurd consequences, it should be avoided and a purposive interpretation be given. In the present case, the respondent has not been able to show that it was authorized in writing to act on behalf of the trust either by a power of attorney or any other written instrument. Unless there is some documentary proof that the trust has authorized its agent to file a suit for eviction on its behalf, it cannot be said that the respondent had any right to file such a suit. Even though it had actually laid out the premises to the appellant and collected rent, the respondent is admittedly not the owner of premises and only claims to be the agent of the trust. Here also, the plaintiff is a company registered under the Companies Act, and necessary authentication, documentation, etc. with respect to the authority of the deponent to present the suit on its behalf. That is lacking in this suit.
What about the appellate court?
Appellate court has also followed line of the trial court, but they are probably acted under the influence of the order of the Honorable Supreme Court, which was pre-evidence stage. And the finding of the appellate court is only more very clear in, if I may take matters to page 63 of the appeal, which is where the appellate court deals with the issue.
63.
Page 63. Page 15 of internal page 15
Just
of
a
the
moment.
sixth line from the top.
Just a moment, please. Yes, if you want.
Bullet I was referring to page 63. Appellate court judgment internal page 15, where this aspect has been dealt by the appellate court. May I place it? Seventh line from the top on page 15, page 63 running through. The defendant at first raised objection on the authenticity of the person who filed the claim, supported with an affidavit. The defendant claims in his written statement that claim has not been signed by the person legally authorized to sign it, and the affidavit also has not been sworn by the person legally authorized to swear. I find that Ramanandan Prasad, claiming to be the constituted agent and attorney of the plaintiff, has filed the claim supported with his verification and solemn affirmation. Later on, a special power of attorney in favor of Ganesh Dutt and Ramanandan Prasad, executed by the Mawari Relief Society through its General Secretary so-and-so, has been filed by the plaintiff on 14/6/2011 with a prayer under Order 7 Rule 14(3) CPC, which has been allowed on 21/11/2011, and the special power of attorney has been taken on record. The said order dated so-and-so has been challenged by defendant before the Honorable High Court in WPC so-and-so, and by order dated 24/4/18, the Honorable High Court pleased to set aside the order dated 21/11/11 with an observation to exclude the said document from consideration during the trial of the case. The said order of Honorable High Court has been challenged by the plaintiff before the Honorable Supreme Court in Civil Appeal number so-and-so, and the Honorable Supreme Court by order dated 14/3/19 pleased to allow the appeal and set aside the order of Honorable High Court, observing therein that though the cause title of the plaint does not state that the appellant Mawari Relief Society is represented through Ramanandan Prasad. However, the verification of the plaint clearly states that Ramanandan Prasad is a constituted agent and attorney of the plaintiff, which in our considered view is sufficient to hold that plaint has been filed by the power of attorney holder who is duly constituted agent. As such, this point of the defendant has already been decided by the Honorable Supreme. So, submission before my lord is this, that when the matter was before the Honorable Supreme Court, it was only with respect to whether that power of attorney could at all have been taken by the trial court on record. Now, unless this document is proved with evidence and the plaintiff being a company, the authority has to be backed up by a resolution of the board of directors. But in absence of these aspects, proving the authority of the deponent to present the suit on behalf of the plaintiff, the suit itself could not have been maintained and was not maintained.
Resolution of board of directors, it's a company.
It's a company. Throughout their case, it's a company.
The defendant is, the applicant was a plaintiff was a company.
Plaintiff was a company. This is the plaintiff. And apart from these aspects, there are other submissions, arguments which can be advanced on behalf of the plaintiff. That as per the case of the plaintiff, he started defaulting in the payment of maintenance and electricity charges from 1st of May 84. 87 is the legal notice, and in 1992, the suit is instituted. So the claim will not with respect to any amount when the legal notice was issued, or the amounts are, if I may say so, the amounts preceding the period of 3 years from the date of institution, those amounts become time bar. So if we go by the August 1992 is the month in which the suit is filed. So August 89, only up to that period, the trial court could have considered with respect to the arrears of charges. Now in the plaint, there is a prayer that to pay main profit at the rate of rupees 3,000 per month. Now the entire case of the plaintiff is that it is a charitable institution and it only charges the maintenance charges, electricity charges, etc. Now while proceeding, it ventures into an arena which is not with in consonance with the identity of a charitable institution, because it talks of profit and enters into the aspect of 3,000 per month rent which can be fetched by the premises later or given on license or lease. And in the appellate court judgment, exhibit 2, the exhibit which I have produced before this honorable court tender, that exhibit 2 was a list of documents allegedly filed on 18/9/92, but it bears the emblem of the seal of the trial court of August 19, a month prior to. So he claims to have filed on September. These I only indicate that it has been conducted by the plaintiff in a manner as if they have taken it for granted that they will be having the degree of eviction, and they have not even cared. And I raise a question to myself.
The documents which were filed along with the claim were lost.
That is their case.
No, that is
Now
not
we
their
are
case.
not-
That is a finding of
We
the
are not
Supreme Court
reopening.
also.
I am not reopening that issue.
Then subsequently those documents were filed at the instance, and then that order has attained finality. Now you want to reopen that.
No, I am not reopening that issue. The second aspect I said on the point of limitation. The third issue is that with respect to finding on the quantum of compensation or the charges, the sole basis of arriving at that is the legal notice of the advocate. There is no ledger produced, there is no authentic document to indicate save and except the legal notice of the advocate. So there is actually lack of any evidence to suggest that there was any fault on his part. Rather, on the contrary, the evidences exhibits marked by the defendant indicates that the electricity charges have been paid even after 1992. And these aspects have been completely not considered. So relevant evidences which are ignored by the trial court, and irrelevant aspects have been taken care of to pass the judgment and decree in favor of the plaintiff. The list of exhibits by the defendant is at appellate court judgment. In detail, it has reproduced the exhibits, which indicates that I had filed the electricity bill payment receipt of July 1992 also. It is filed in August 1991. Exhibit B by 10 is electric bill 30th July at page 54 of the memo copy. B by 10 is the electricity bill of 30th July 1992. Then several bills I have produced. That it is not that I was entitled, because even in the application which is exhibit 1, that was a photocopy laid in evidence. That also does not indicate that there was any monthly charges fixed upon me. The document by which a license has been granted to me to occupy, it only talks of a one-time payment. Exhibit 1, if one can see, is the Avedan Patra. आवेदक का नाम सो एंड इन द टर्म्स एंड कंडीशंस मुझे स्वीकार है कि कोठी या कमरे की बुकिंग के लिए 60 रुपये या 35 रुपये जो मैं जमा करूंगा वह एक बार जमा करने के बाद किसी भी हालत में वापस पाने का हकदार नहीं रहूंगा। इन रुपए में से 25 रुपये काटकर बाकी संचालन खर्च में मिलान किए जाएंगे और न आने पर पूरा जब्त हो जाएंगे। कलकत्ते से बाहर रहने वाले को 10 रुपये पोस्टेज खर्च देना पड़ेगा। दैट इज ऑल विद रिस्पेक्ट टू द मॉनेटरी एस्पेक्ट इन द एप्लीकेशन।
You must have formulated the substantial question
Yes,
of law.
ma'am.
Which?
C and D, my lord.
C and D.
Page 9 of the memo.
Essay number 16 of 2026. This appeal has been filed against a judgment dated 23/12/2024 within bracket decree signed on 2/1/2025 bracket rules passed in civil appeal number 143 of 2020, passed by learned additional judicial commissioner in Ranchi, whereby the learned first appellate court has upheld the judgment dated 13/3/2020 within bracket decree sealed and signed on 21/3/2020 bracket in eviction tax suit number 5 of 1991. Now original suit number 2343 of 2019 passed by learned civil Ted Union Division 1 Ranchi. The title suit seeking eviction was allowed with charges of Rs 22,464 as well as present and future pending charges. On account of maintenance charges or electricity charges. And the first appellate court has upheld the judgment passed by the learned tribunal. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the appeal is fit to be admitted for final hearing on the proposed substantial question of law mentioned in proposed substantial question of law number C and D, which is quoted as under. The learned counsel for the appellant has submitted that the plaint was filed through the power of attorney, through the alleged power of attorney dated Ramanandan Prasad, but the power of attorney was never exhibited before the court. And therefore, the suit filed at the instance of Ramanandan Prasad was itself not maintained. The learned counsel submits that both the learned courts have not taken into consideration this aspect of the matter. He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket news 10 SCC 601, para 8 and 9. इसको quote करना है. And also the judgment reported in bracket 2011, bracket news 11 SCC 524, para 14. The learned counsel has further submitted that a deputy has also been passed with respect to payment of rupees 22,464 against the alleged dues and he has further submitted that the learned courts have failed to take into consideration the exhibit A/12 and A/2. Exhibits B series and also D series. B and D series, correct?
Well,
While quantifying the dues. He submits that these documents show payment to the electricity department and to Ranchi Municipal Corporation. यही आपका केस
well,
arguments concluded, post for orders.
but may I please be highly also in the meantime?
We are there, so we will.
Date.
Arguments concluded करके ना इसको CAV का order ड्रॉप करेंगे और order के लिए date डालेंगे. I give a date when this will be announced. एक आ ही जाएगा जल्दी आ जाएगा. Next.
From day list for admission item 81, first appeal 5 of 2026.
CMT एक कमेंट है एक और परचेज में
First appeal.
फर्स्ट
Admission के लिए
एडमिशन
FA 5 of 2026. Admit. Issue notice to the respondents for which requisite under speed post be filed within a period of 1 week frame.
2 weeks
2 weeks frame. Call for records from the concerned court. Let this order be communicated to tax. Office to tax speed post delivery post on 26th of February.
From supplementary list for hearing on order 41 rule 11 item 61, second appeal 2 to 8 of 2023.
Second appeal number 228 of 2023. Appellant absent. Goes to my.
From day list for hearing on order 41 rule 11 item 82 second appeal 191 of 2018.
Appellant. Second appeal number 191 of 2018. As per office, nobody appears on behalf of the appellant. As per office note, the certified copies of the decree passed in partition suit number 149 of 2006 and title appeal number 34 of 2015 were sent to the Judicial Commissioner for correction. And in response, a letter number 93 dated 8/1/26 has been received stating that name of Ajay Oraon, respondent number 2, has not been mentioned either in the cause title of the memo appeal in title appeal number 34 of 2015 or in the cause title of the plate of partition suit number 149 of 2016. Accordingly, the defect in connection with party position, including Ajay Oraon as respondent, still continues. Counsel for the appellant is directed to take steps either to delete the name of Ajay Oraon from the cause title or to file appropriate petition in connection with Ajay Oraon, explaining the circumstances under which he has been made party in these proceedings. By 11th of February 2020, since the counsel for the appellant is absent, let a soft copy of this order be communicated to the counsel for compliance.
Item
ये
83.
कैसे ऑर्डर 41 में लग डिफेक्ट तो कंटिन्यू कर रहा है ना इसमें चेक कर लीजिए.
Item 83 second appeal 397 of 2018.
Appellant.
Three 397.
397.
Yes. Last date's order, Your Excellency, because my submission wrote that the entire trial was vitiated
Yes.
and therefore
Yes, counsel. The entire trial has vitiated because the appellant before the court इसमें लगाया नहीं order लगता है.
Your Lordship had called for the entire records itself. And
My submission was that after conclusion of my evidence, with the first round, the state files an intervention, my claim was entirely against the private party.
हम कुछ और रिकॉर्ड एक सेकंड हम कुछ और रिकॉर्ड सोच रहे थे ये जरा पढ़िए
I have received the file.
रिसीव द फाइल
Just 1 week before.
सो
So I was aware. I was just I want
पढ़िए
some
जरा
time.
और
हाँ, correct.
Some time ago. It's all part of it. Preliminary counsel for the appellants has submitted that there has been serious irregularity in conducting the trial. He submits that the plaintiffs have filed a suit only against 2 defendants, both sons of Sri of Ram Sevak Bhagat. However, they state filed an intervention application which was rejected on 6/9/2000, and ultimately the evidence of plaintiff was closed on 31/1/2004. Thereafter, the state filed another petition seeking intervention petition, which was allowed on 1/4/2005, and the state was directed to file written statement, but plaintiff was neither given in the opportunity to give further evidence, nor in the opportunity of granted to amend the claim. The learned counsel submits that the reports be called and produced as a substantial question of
पता ही है
law.
सब्सटैंशियल क्वेश्चन ऑफ लॉ बिना बनाए तो सेकंड अपील नहीं कर सकते है ना तो आप बना देते हैं आप इसको एड्रेस कर दीजिए इस ग्राउंड पे तो केस को पेंडिंग रखने का कोई पर्पस नहीं है ना व्हिच इज ये सब्सटैंशियल क्वेश्चन
That it would be that whether the entire trial itself was vitiated on account of the fact that this is the only, this is one, and the second one would be misconstruction of exhibit 5 and 13, but those would be on merit. I must say that my first submission itself would be that the entire trial was vitiated.
No right was last time followed
And actually, it would be the state who should answer to this, because they are the persons who are not aggrieved by this remand order. Only the state can say, because state have been impleaded, and then only and the trial court and the appellate court have held that it is the property which belongs to state.
copy has been state copy has been given.
suit was dismissed
It was also dismissed on the ground that it is government land.
Suit was dismissed, and then
where is the
appeal.
state is a party
State is a party, respondent of the
where
they are defendant second party, and they were the interveners before the trial.
notice was issued upon them notice has been served
And the state council may also appear, because it is the deputy commissioner role.
notice is
Can I
served
serve it through AG office itself?
notice served है वो आएंगे तो हम लोग क्या करेंगे
One date will be given, I will inform.
My submission would be that.
show it from the record
Yes, I'll show from the record.
show it from the record records
Yes.
have been
Your
received
Lordship
show it
has
from the
called for the record, Your Lordship has seen the records.
like
It's okay.
The courts have held two learning that it is government land. Page number 30, the last line, the deed of the trust relied upon by the plaintiff appellant state itself shows that the ownership was not transferred. No right was given to transfer the land in question.
Few orders are shown, few of the orders of the trial.
you just give me the sequence and all
Yes.
try for
Trial.
which order
First, I
this is from
instituted
which
suit.
court Dhanbad
Yes, Lama. I
Dhanbad
instituted suit, and thereafter 6/9/2000 order may receive.
6/9/2000
2000. Yes. Plaintiff are in attendance, record is put up for order petition dated 14/2/2000 under order 1 rule 10 CPC for adding party to the state of Bihar and CO Bagmara as a defendant in the suit. Defendant was also filed a petition on ITMA to call for report from Circle Officer Bagmara. This petition relates to petition under order on so and so, and then for being included as a party. Then concluding lines of the same order may kindly be seen. Under the facts and circumstances of the case, I am of the opinion that the government of Bihar or Deputy Commissioner Circle Office Bagmara is neither the necessary nor proper party. Hence, in the circumstances, the petition dated so and so and the petition dated so and so, according for the report Bagmara so and so, stands rejected.
Rejected.
Then,
This is 692,000.
yes, 690.
Order 1
Rule 10 filed by the state.
by state. Rejected.
My suit was against two private individuals who were encroaching on my land.
That's right. Then
Then on 5/1/2002,
5/1/2000.
2002, I had produced one witness and then,
No, no, just a moment. On 25/8/2001, there was an amendment seeking relief.
yes, but till that date, state was not a party. My amendment was against them for adding alternative relief of recovery of possession.
Okay.
Not against state, my claim was not against state. Then 31/2004, 30/1/2004. After rejection, state is not a party in this till the entire proceeding is being taken place.
Date
30/1/2004.
30/8/2004. When was your evidence closed?
Yes, this is the date actually. 30/1/2004.
Please, yes.
The last three lines, वादी का साक्ष्य बंद किया जाता है और सो एंड सो को प्रतिवादी साक्ष्य हेतु प्रस्तुत करें. Then several defendant witnesses were examined, which would be apparent from next page 31/5/2004. After two lines, प्रतिवादी की ओर से साक्षी सो एंड सो की गवाही दी गई. ये सब लिखा है. Then other defendant witnesses are being examined, and the last 5/2/2005 may kindly be seen. 5/2/2005.
Just a moment. This is 31/04. Evidence of plaintiff closed.
And thereafter, evidence of defendant started.
35/04. Records evidence of defendants. Okay. Then
Several 3 to 4 witnesses were examined, and 5/2/2005 may kindly be seen. 5/2/2005.
yes.
उभय पक्षों की उपस्थिति में अधिवक्ता द्वारा वादी की ओर से साक्ष्यों की सूची प्रतिवादी के अधिवक्ता की प्रतिलिपि देते हुए प्रस्तुत की गई. प्रतिवादी साक्षी समद अंसारी को शपथ पत्र पर प्रति परीक्षण अंकित करने हेतु अधिवक्ता आयुक्त द्वारा प्राप्त कर ली गई. That means after his evidence, Samad Ansari returns. The pleader commissioner was appointed. Witness Samad Ansari, deposition is recorded and returned back to the court. This is what will be recorded.
Okay.
And then next page.
After commission.
Yes. He is the defendant witness, Samad Ansari. Then next page. 18/2/2005.
This date may not be relevant. This 5/2/2005 may not be relevant.
It is relevant. It is relevant because till that date, the several defendant
That's why this
witnesses.
is going on.
Yes, defendant evidence was going.
That's right.
This is only I wanted to point out. And then next page, 18/2/2005. उभय पक्षों की उपस्थिति अधिवक्ता द्वारा प्रस्तुत की गई अधिवक्ता आयोग द्वारा प्रतिवादी संख्या साक्षी समग्र अंसारी का प्रतिपक्ष परीक्षण अंकित कर न्यायालय में प्रस्तुत किया गया। आवेदक राज्य की ओर से एक आवेदन वादी के अधिवक्ता को प्रतिलिपि देते हुए ये प्रस्तुत की गई प्रस्तावली दिनांक इतना प्रति उत्तर के लिए रखें। दिस इज सेकेंड ऑर्डर 1/10 एप्लीकेशन filed by the state, and it is being now decided by next page order, that is on 1/4/2005. Next page. Yes, 1/4/2005. आवेदक राज्य की ओर से दिनांक 17/2/2005 को अंतर्गत आदेश 1 नियम 10 व्यवहार न्याय प्रक्रिया संहिता का प्रार्थना पत्र प्रस्तुत किया गया है, जो संक्षेप में इस प्रकार है। And then they claim intervention, and this is being allowed by this order. After 3 pages,
2405
yes,
allowed.
allowed.
Then what happened?
Then this is allowed, and they are made parties, and the concluding portion is that he is made party. I'll read out last time. इसलिए आवेदक राज्य की प्रार्थना पत्र स्वीकार किया जाता है और आवेदक प्रतिवादी संख्या 3 के रूप में वाद पत्र में प्रतिस्थापित किया जाता है। प्रतिवादी को आदेशित किया जाता है कि यथाशीघ्र लिखित कथन प्रस्तुत करें। अभिलेख दिनांक इतना को प्रतिवादी संख्या 3 की ओर से लिखित कथन हेतु प्रस्तुत करें।
The written submissions.
Written statement of defendant number 3, who was the newly added, that means state. Matter was now placed for written statement by state, newly added party.
State. Okay.
And then next page I filed a review petition, but ultimately that is not relevant. I'll just show.
Then what happened?
Yes. Then the state was barred 2-3 times, and then ultimately its written statement was accepted by order dated 3/5/2006. 2-3 times it was rejected initially, extension of time ultimately, but it was allowed by order dated 3/5/2006. In the above circumstances, I am reading the conclusion.
Yes.
The under aforesaid discussion, in my opinion, the latest statement filed by defendant number 3, State Government of Jharkhand, represented through Deputy Commissioner, is allowed with a cost of ₹1,000, and order dated so and so is recorded. And then next page, next order, 22/5/2006, after 5 lines, सुना प्रार्थना स्वीकार किया गया, प्रार्थना स्वीकार किया गया। प्रतिवादी राज्य को छोड़ से प्रतिवादी को निर्देशित किया जाता है कि दिनांक इतना को साक्ष्य प्रस्तुत करने हेतु अंतिम अवसर प्रदान किया जाता है। Then the matter is now being placed for evidences by the defendant.
No, it must be for the evidence of both the parties.
अलग से और विचायक गठन नहीं करना चाहते।
एडिशनल इशू नहीं बन रहा।
इशू नहीं फ्रेम करना चाहते हैं। सुना, एंड देन मैटर इज प्लेस फॉर द एविडेंस ऑफ डिफेंडेंट नंबर 3।
प्रतिवादी राज्य को छोड़ शेष प्रतिवादियों को निर्देश दिया जाता है कि दिनांक इतना को शेष प्रतिवादी
साक्ष्य प्रस्तुत करने हेतु अवसर प्रदान किया जाता है। शेष प्रतिवादी
remaining defendants.
remaining that means
defendant witnesses.
plaintiff number 1,
How many
defendant number
defendants
1
were
and defendant number 1 and then repeated direction for production of evidences by the state, and then order dated 28/7/2007. This is also relevant. Now the state files a petition that I have not cross-examined the plaintiff's evidences. Please allow me to cross-examine my witnesses. So it files a petition, and by this order, it is allowed cross-examination of my witnesses. That was allowed by the order dated so and so, and then I am cross-examining. This is all. And then the matter is posted for final argument, and it is ultimately and the matter is disposed. This is one. Now,
No, so what is the procedural lap? What should
Yes,
have the
yes,
court done?
yes. I here was a case. Otherwise, I would not have continued. Here is a case that my entire case was initially against the defendant number 1 and 2 itself. Only against two private parties against whom I say that they are encroaching on my land. This was my case. Now state files an application, it gets it rejected, then second time it files an application and it is impleaded. None of my statement I could have not have anticipated that I would have to state is disputing my title. I could not have anticipated. On the date when I filed a suit, if I would have, then my pleading would have been otherwise.
Then once the state was impleaded as party
Yes,
and the written statement of the state was taken on record,
yes.
then under such circumstances, you should have sworn to file your additional amended your plaint.
I could have. I will not say that I could not have.
That is the procedure of
I could not have. I will not say that I could not have. But here is a case where my entire trail is against a private party.
That's right, but why didn't you take steps for amendment of your plaint? It was your lapses.
Not
No
my
separate
lapses,
order
it
is
was-
required to be drawn. What do you mean
It was
separate order?
continuously, it was the matter was never placed. Now the moment
It's a
the
mishandling
state
by the
was
councils. Why
No.
do you have to blame the court for that?
no, I'm not blaming court. I'm not solely blaming court. Now the moment state was impleaded as a party, then at least I should have been given an opportunity to amend my plaint suitably, apart from adding the state as a party. Only
See, the
addition would not.
state was added as a party. Unless the state would have filed a written statement, you would not have known that what was the stand of the state.
Yes.
Correct?
Yes.
So once the state filed the written statement, then you could have taken steps to amend the plaint. Who stopped you from doing that?
But
No judicial order is required for that. Is there any judicial order required?
no.
Then you have not taken steps to amend the plaint. And then you are blaming the state.
No, I'm not blaming.
Blaming means
I say that it is actually
that
a
no
case.
opportunity was granted to amend
Now, what would happen ultimately?
and then you just see one more thing, that your witnesses were also produced for cross-examination.
But
Did you
on-
cross-examine them?
upon
Did the state cross-examine them?
state cross-examined my
That's right,
witnesses
that's
on
right.
recall.
You were conscious
On
of the fact.
recall, it was
You were
they were
conscious of the
cross-examined.
fact that the state was cross-examining your witnesses. But you did not take any steps by saying that yes, now a different stand has come. A person may choose not to amend the plaint in spite of addition of party, isn't it? It is his discretion and it is his wisdom whether he would like to amend the plaint or not to amend the plaint. There is no court's order is not required for that purpose.
Court's order is not required, but actually, after addition, after the first time, the second time when the state was
You
impleaded,
should
then
have challenged that order. What is this? You are raising it for the first time in second appeal. Parties are acting pursuant to that order.
but even otherwise, I'll establish my case on merit.
You argue on merit, but
No.
not on this ground. You are not inclined on this ground.
I'll argue on merit.
देखिए, just a moment. Essay number 397 of 2018. The Learned Counsel for the appellant has placed the order sheet from the Learned Trial Court's record and has submitted that the plaintiff had filed case title suit against two defendants only. However, the application filed by the state seeking addition of party, seeking intervention, was rejected by the order dated 6/9/2000. Subsequently, the evidence of the plaintiff was closed on 30/1/2004 and the evidence of the defendants commenced. However, on 18/2/2005, an application was filed by the defendant seeking addition of party.
Not by defendant, by state itself.
18/2/05.
Your Lordship is referring to what dated?
18/2/05.
Eighteen to 2005 is the
That's it.
application by the
Another
state.
application was filed by the state seeking intervention. Again under order 1 rule 10. He submits that the state application was allowed on 2/4/2005.
It is on, acha,
2/4/2005. And thereafter the evidence of defense witnesses continued. The state was granted repeated time to file their written statement. And ultimately the written statement was allowed. The written statement filed by the state was taken on record by order dated
3/5/2006.
3/5/2006 upon payment of cost. The Learned Counsel submits that thereafter again the evidence of the defense witnesses continued. He submits that a petition was also filed by the state for recall of witnesses of the plaintiff for their cross-examination, and the state duly cross-examined the witnesses of the plaintiff. The Learned Counsel has submitted that the court did not pass any order asking the plaintiff to amend the plaint in view of addition of the state as a party dependent and in view of the written statement filed by the state. And therefore, on account of procedural lapse, a substantial question of law is required to be framed. After hearing the Learned Counsel for the appellant and going through the records, this court finds that the application for intervention was allowed and the state also filed written statement and also got the witnesses of the plaintiff recalled for cross-examination. It was for the plaintiff themselves to take a call as to whether the plaint was required to be amended or not. And no specific order of the court is required for that purpose. Accordingly, this court is of the view that on the alleged procedural lapse, no substantial question of law is required to be framed. At this, the Learned Counsel for the appellant has submitted that otherwise also he has merits. So he has substantial question of law so far as the merits of the case is concerned. Argue.
Question is, now whether this is a property belonging to state or not. Now, first question of law which I propose is, based on a fact that in earlier there were, I'll be very brief in this point. Now, the land was settled in the year 2005 by a registered document, was in the year 1948, and then it was settled by the Savayat to whom the earlier Raja had settled the property. Now, thereafter, the property in the property which was settled to the ancestor of the plaintiff, now they constructed several shops and other things, and then inducted tenant also in those properties. Now, right from thereafter, they had inducted several tenants and there was several litigation. In one such litigation, the eviction decree was passed. In that litigation, state intervened during the stage of execution and filed a petition under Order 21 Rule 58, claiming that it was the property of the state. And that was rejected by a reasoned order which is already marked as Exhibit 2. So what would be the effect now? Now the effect would be, in an execution case, state claims that the property belongs to the state, and it is by a reasoned order it is rejected that you have failed to establish your title and the state's claim is rejected. Then it would be barred by constructive res judicata in terms of order section 6, section 11, and explanation would be 8.
The property has been declared to be the property of the state.
Yes.
You are not aggrieved.
He is not agreeing. He is,
Because
because he is enjoying the benefit of it. He does
state
not.
has made settlement with them or what?
No, they are not claiming settlement. They say that although we are in the property of the state and it is the state's property and we are trying to get the settlement done by the state. This is all they are writing.
They are in possession and they are not
They are in
aggrieved.
possession.
They are not aggrieved with the finding that the property belongs to the state.
No, they are not. They are not. They are the persons who say that this property is not yours. This is the property of the state.
Okay. Where is the discussion of Exhibit 2?
Yes. In appellate court's order itself.
Yes, please.
Page number
Para 8.
Par-
अच्छा para 8 में तो मेरा डिस्कशन है नहीं हम ठीक है peruse the document para 15 internal page 12 peruse the document exhibit 2 this is the document which I am is this
Internal page?
internal page 12 of the appellate court's order
Yes.
para 15
Yes, please.
peruse the document. Exhibit 2 is certified copy of order dated 4/8/1976 passed by the Reverend Munsef Dhanbad in miscellaneous case number 1875, State of Bihar versus Shardenu Narayan Singh. It is so happened that Shardenu Narayan Singh had filed title suit number 158 of 68 against Gauri Lal Dadait for his eviction from plot number so and so under Khata number 312. That suit was decreed and execution case number 1875 was filed. The state of Bihar had filed a petition under order 21 Rule 58 CPC by stating that the suit land belongs to the state of Bihar, that the petition was dismissed by the learned Munsef, against which the state filed no appeal. Earlier, original defendant Gaurilal Dagaich had filed miscellaneous case number 18 of 71 for setting aside ex parte decree passed against him, which was dismissed on 23/12/1971. Then he filed a miscellaneous appeal of 272, which was also dismissed on 3/5/1972 by the learned district judge Dhanbad. Then he filed an objection in execution case, which was dismissed. His servant Jagdish Rai filed a claim so and so, which was dismissed. His son so and so filed an application which was rejected. Then the CEO had filed a petition under Order 21 Rule 58 CPC on perusal of the order passed by learned Munsif Dhanbad on 4/8/1976 is miscellaneous case number 1875. I find that the state government has not produced any document to show that plot number 866, 999, 2000 and 1001 were vested in the state. Since no document has been filed by the state government, so the petition filed under Order 21 Rule 58 was dismissed. This is observation, and what is the reason for discarding this is that it was the state authority should have produced, and they have not done, and therefore that finding is reason for discarding that finding I have not been able to get.
Now, page number 14, the last one. I find that on notice the CO has filed a reply by stating that they then CO Narmara has allowed rent exception case number circumstances land under 86699 Khat number and Shawar Kasina Singh. It was wrong because he then CO in the year 1991 and no count.
This is the only thing which he says.
Further has stated that by
This is the only thing.
When
And
the
then
person files an objection in the execution proceeding, is it to be tried like a suit? This objection was required to be tried like a suit.
I'm not sure. Why I am referring to section 11 explanation 8.
Like, so,
Even if it is assumed that the executing court has limited jurisdiction, to that extent we can go, then whether it would amount to res judicata or not. It says that the res judicata says that no court shall try any suit or issue also word is also there, in which the matter is directly and substantially in issue, has been directly and substantially in issue in former suit between the same parties or between parties under whom they or any of them claim litigating under the same
you are
title.
reading section 11?
I am reading section 11.
Section 11, explanation.
Explanation 8 would be relevant, but I am reading the first section 11 itself. No court shall try any suit or issue is very important, in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent.
Was it between the same parties?
It was between the same parties because the
They were
state-
also there in that suit?
No, some other tenant. I said that there were several tenants in the property and we used to file eviction suit again if the matter was required.
No, but in a case when they were not there
Yes.
over the property, how will it bind them? under-
No, it would not bind them. I say that because now the property has been held to be the property of the state and therefore my suit has been dismissed. It was barred against the state. This bar would come against the state because state filed an objection and state's claim is being rejected on the
It
ground.
was not the same property,
Pardon?
because it was not the same property, because it was for some other tenant.
It was for some other tenant, but what is the finding? That the state it is a portion of the same property. And
How
the
you
state,
you see, it was in connection with suppose there is a big chunk of land,
yes,
right? It is a portion of it, maybe 1 acre, is in possession of Mr. A,
yes,
and there is a suit in connection with Mr. A,
Yes.
that plot number
yes.
1 acre, and state ultimately is not able to justify its title over the over that plot.
Yes.
Then under such circumstances, that particular judgment will apply to the entire khata number.
Yes.
How?
Why? Therefore, I'll answer to your Lordship's
Yes.
point. I'm answering. Now it was the claim of the state that all these plot numbers, including the suit plot which is involved in the incident case, all these three plots are the properties of the state.
That's right. They
And
might
that
not
is
have
being
been able
rejected.
to, they might not have been able to prove their title in that particular case qua a particular portion of the property. Right?
How
That
then?
will not act as, suppose there is a suppose you have a property, huge property, right, with respect to one residential building, you lose your case. Does that mean that you lose your case for the entire?
For reason that the state was claiming that all these three plots are the plot of state. This was the reason.
Maybe that state was claiming.
And it is.
Maybe that state was claiming, so only qua that property, the suit will be barred by res judicata. How will it apply to rest of the properties?
That particular.
Maybe that the genesis is the same. Maybe the genus is the same with respect to the property. Maybe in the same breath, the state says that the entire property is my property, but that property was not the subject matter in the earlier.
But a portion of it was.
Maybe portion.
Then what would happen ultimately? The basic claim of the state itself was.
No. स्टेट तो पूरा ही कोई क्लेम करता है, उसका कोई पोर्शन क्लेम किया
नहीं, वो लिखा है, वो प्लॉट नंबर लिखा है. अगर प्लॉट नंबर नहीं लिखा रहता,
वैसे नहीं होगा. You see, जो प्रॉपर्टी डिस्प्यूट में था, जजमेंट से उतना ही प्रॉपर्टी का होता है, उसके बियॉन्ड नहीं होता है. उसके बियॉन्ड 1 इंच भी नहीं होता है.
ये तो उसमें लिखा हुआ है कि हम ये तीनों प्लॉट मेरा है. ये तीनों बेसिस.
अगर मान लीजिए किसी और सूट में where only A property is involved and you take a plea that A, B and C the entire property belongs to me, it will be binding only for the A property,
नहीं,
not the entire.
यहाँ पर कैसे सेम पार्टीज और एटलीस्ट स्टेट एंड ये नहीं वो नहीं.
पार्टी सेम है.
हम बोल रहे हैं पार्टी सेम है, प्रॉपर्टी भी सेम इसलिए है because the state is claiming that these three plots are the plots of
state and claim that the entire state of Jharkhand is theirs.
नहीं वो नहीं है. यहाँ पर तो पर्टिकुलर प्लॉट नंबर दे रहे हैं, 3 प्लॉट लिख रहे हैं.
जितना प्रॉपर्टी इन्वॉल्व है बस उतना ही पॉजिटिव है, उसके बियॉन्ड नहीं लगता. और वो प्रॉपर्टी तो ये क्लेम ही नहीं कर रहे हैं.
हाँ, वो क्लेम नहीं कर रहे
They
हैं.
are not in possession with respect to that property which was involved in the earlier titles.
उसका नहीं क्लेम कर रहे हैं, लेकिन मेरा तो जब टाइटल स्टेट का डिक्लेयर हो जा रहा है एंड दे आर गेटिंग बेनिफिट ऑफ दैट ऑर्डर, तो अगर स्टेट का प्रॉपर्टी डिक्लेयर हो रहा है तो हमको अगर वो उनका जो बेसिक क्लेम है that I find that the state government has not produced any document.
Here the property is related to plot number
866.
866. In the earlier case, the property was relating to plot number.
Plot number.
Exhibit 2 है ना?
1000 लिखा हुआ है लेकिन वो दूसरा प्लॉट इसी में से था, ये चारों में से 2000 या 2001. But it was not once 866.
ये नहीं चलेगा. ये नहीं चलेगा, ऐसा नहीं होल्ड कर सकते.
Entire claim was now between me and the state.
कोई केस
स्टेट का जो बेसिक
सब्सटेंशियल क्वेश्चन ऑफ लॉ.
नहीं स्टेट का जो बेसिक ये है.
Firstly, it is absolutely on facts. No. Secondly, on the face of Exhibit 2, I am not inclined to frame any issue. Exhibit 2 is not the same. Exhibit 2 is not relating to the same property.
अच्छा हम तब और हम नहीं दिखा दे रहे हैं.
हो गया बस.
नहीं इसमें बहुत मेरिट है, ऐसे ही हम नहीं बोलते, हम दिखा दे रहे हैं. अब हम
बस लास्ट पॉइंट.
लास्ट पॉइंट.
You choose your best.
If I am not able to convince, I am done. Now your lordship, what happened that in 19th there were 2 land ceding proceedings. This is very important. Therefore your lordships have noted my submission in last order, Exhibit 5 and Exhibit 13. Now what are those two certified copies of land sealing proceeding? This is very important. Land sealing proceeding. Now there were 2 proceedings which took place. One was under Bihar Land Reforms Fixation of Sealing Area, that means rural sealing, where under that Bihar Sealing Act, a person is entitled to hold a particular area only within a ceiling limit of within rural area. So that limitation, if I exceed in holding that land, then my excess land is acquired by the state. So that is the
1961 Act.
1960. So a proceeding was
This is
initiated.
Exhibit 5.
Yes,
1961 Act.
1961.
And Exhibit 13 is?
Exhibit 13 is a affidavit filed by the state before the Supreme Court. And they mention in that, mentioning this plot number 8666, that it has been allowed to be retained by us, and therefore my other land is being acquired. This is their affidavit before the Supreme Court. So
866 has been allowed to be retained.
retained by me. Now here I'll show. Yeah. Kindly see first Exhibit 5.
Where is Exhibit 5 discussed?
Exhibit 5 में kindly see.
Discussion दिखा.
हम दिखा.
Now I will take your words as correct. You just show me the discussion.
हम दिखा. नहीं लेकिन एक बार. Exhibit 5 देखा जाना एक. हाँ.
I take your words.
हाँ,
The Exhibit 5 में state ने बोल दिया है कि this particular property has been released to you.
Not really. It has been allowed to be retained by me.
That's it.
My excess land is being acquired.
That's right.
Now why
Under 1961.
why I am placing this, that if this property would have been the property of state, I would have been entitled to my other property. In lieu of this, my other
Certainly.
genuine property has been acquired by the
Certainly.
state, holding that it is an excess land.
That's
Now what they say, it discards my claim.
कौन सा exhibit? Exhibit 5. Exhibit 5 is not the affidavit 5 before the Supreme Court.
Exhibit 5 is
Not the Exhibit 5 is again relating to 866.
LC case number 9
Yes.
of 73-74.
That's right. नहीं, LC case number 8 within bracket 5 of 91-92.
नहीं 9 है. 9 है 73-74.
अच्छा.
And in this I am allowed to retain khata number 312, plot number 866, 0.26 decimal, which is exactly the suit plot.
खाता नंबर प्लॉट नंबर लिखा होगा ना?
हाँ.
प्लॉट नंबर कहाँ लिखा?
किसमें ये
Exhibit
जो ये वाला लैंड सीलिंग वाला में. हाँ. Kindly see annexure 2 3 पेज के बाद.
हाँ, हम देखते हैं.
Right side में annexure 2 है. Area and description of land which is allowed to be by the collector to be retained. ऊपर में लिखे हैं.
हाँ जी.
उसका कतरास है.
866.
हाँ, कतरास है 5 लाइन के बाद ऊपर से 5. खाता नंबर 312 and plot number 866 0.26.
प्लॉट नंबर 866 का
हाँ,
कितनी area है
866
total?
हाँ 866 है और 0.26 area.
The entire area of this is this only.
Yes. And this is the shoot plot. Last 3 lines of page 30.
staying in
last 4 lines. Exhibit 5, page 13. Exhibit 5 is the settlement paper. It would not be settlement paper. Final publication under provision of BLR Act, Urban Land, Urban City. It would be BLR Act, not Urban City. PLR Act showing that the suit plot number Khata number 312 in Annexure 1 given by Shardenu Narayan in HC case number 9 of 1973-74, plot number 866, area 0.26 acres under class number 4 and plot number so and so under class number 4 was shown in possession of Shardenu Narayan Singh. Annexure 2 is the area and description of the land which is allowed by the collector to be retained by ex-landlord of that 2 plot under Khata number 312, fines mentioned. This case was filed in 1973-74 and final publication was made. While rent assessment case number so and so, the CO allowed the prayer of the petitioner for realization of so and so for plot number 866, 999 and so, area so and so, Khata number 312 on the basis of registered deed 3789 dated 24/4/1948, executed in favor of Shardenu Narayan by the ex-landlord Purvendu Narayan Singh. I have already held that Purvendu Narayan Singh, being Shabayat of so and so, had no right to execute any deed in favor of any person. Exhibit 8 and document filed are related to so and so, and then with regard to other exhibit, it is discussing.
So you are claiming this property by virtue of transfer made by Shivayat?
Shivayat, yes,
The court has held that the Shivayat did not have the right to transfer.
to transfer. So it ultimately what it did, it fixed it held that Shivayat did not have any right and a proceeding under 4H was initiated, and then there a recommendation was made for annulment. But no annulment ultimately was made by the state, and annulment under 4H has to be, final order has to be passed by the state. That was only a recommendation. Now in that itself, let us assume that that is correct, then also under that particular order of recommendation, complete right was not annulled. It said that the Shivayat would be given a sum of rupees 7,500 annuity. Annuity was fixed. This is the only. So complete, it did not say that he did not have a complete right. And as I pointed out earlier, now I cannot be deprived of 2 properties simultaneously. If if this is held that it was not my property, the state has already taken my other property. It is not that I am taking the property of the state. If at proper time this would have been pointed out, then my other property would not have been declared to be surplus, and the state would
Where
not
is the
have.
affidavit of the state filed before the Honorable Supreme Court?
Yes,
Which
that
is
is
that
30.
exhibit? And whether this statement was brought to the notice of the was specifically exhibited? या खाली उसी को exhibit कर दिया पूरा affidavit?
वो affidavit है खाली.
और उसके बाद वो statement?
वो कौन सा वो?
कोई document exhibit
नहीं,
करने से तो नहीं होता ना?
खाली वही.
तो कैसे होगा?
नहीं, तो वो तो एडिशनल डॉक्यूमेंट है, हम तो इसी को बोल रहे हैं. एग्जिबिट 5 ही कंक्लूसिव होगा, because they themselves say that this was final publication, and the suit property is only 26 decimal. And if I am being deprived of, I'm repeating that line, as your Lordship pointed out, that if this proper time, if this would have been brought to the notice, I would have claimed my other property would have not have been acquired by the state or declared as surplus. My other property has been taken over, declaring it as a surplus. And then after that declaration, I am bound by that order of land acquisition proceeding, and then one portion is again being taken from me. How these two can be allowed? Therefore, I say that my question was that whether there is any misconstruction of Exhibit 5 or not. This the state themselves say, and the trial court also says that this is a final publication.
The learned counsel of the appellant has submitted that the present proceeding, the stand taken by the state was itself barred by res judicata, inasmuch as in the earlier suit,
Page number 14 में edit some paragraphs.
in the earlier suit, the state had in the execution case filed arising out of the earlier suit, the state had filed a petition under Order 21 Rule 58 of CPC, which was dismissed. He has referred to section 11 of the CPC and has submitted that after dismissal of the petition under Order 21 Rule 58 of the CPC, there was no scope for the state to take a stand that the property belonged to the state. This aspect of the matter, according to him, has not been properly considered. However, during the course of argument, it appeared that the present suit relates to plot number 866 and the earlier proceeding in which the state had filed petition under Order 21 Rule 58 CPC was relating to plot number 1000. Since the identity of the property is not the same, and the parties in the earlier proceeding were also not the same, the plea of res judicata does not arise, and therefore the same does not fall for consideration as a substantial question of law in this case. At this, the learned counsel for the appellant has submitted that there is one more substantial question of law, one more question which arises for consideration. He has referred to Exhibit 5, which is the final publication under the Bihar Land Reforms Act in a proceeding regarding fixation of ceiling area, and has submitted that in the said proceeding, the plaintiff was permitted to retain khata number 312, plot number 866, area 0.26 acre. The learned counsel submits that while
0.26 26 decimal, 0.26.
0.26 acre, the learned counsel submits that while allowing the plaintiff to retain the said property, the other property was taken away by the state.
Paragraph order 9 maybe 3 minutes.
Just a moment. Abhi aapka kaam nahi. The learned counsel submits that on the one hand, the appellant was permitted to retain the suit property involved in the present case, and on the other hand, in the land ceiling case, and on the other hand, with respect to the same property, the title of the state has been declared. He submits that the impugned judgment suffered from perversity so far as the appreciation of Exhibit 5 is concerned. He has also placed the Exhibit 5, which is available in the records received from the concerned court. After hearing the learned counsel for the appellant on this point, this court is of the view that a substantial question of law arises for consideration on the following point, whether the judgment passed by the court, by the first appellate court से हो जाएगा, suffers from perversity in the matter of appreciation of Exhibit 5. First,
That is.
the private respondent has already appeared. Counsel for the appellant is directed to serve 2 copies of the memo of appeal with enclosures and synopsis in the office of Lawyer Advocate General, who shall appoint a state counsel to represent the state. आपका बाकी सब पॉइंट हम रिजेक्ट कर दिए,
ठीक है,
इसीलिए कर दिए जब इतना सुने हैं, नहीं समझ आया तो रिजेक्ट करना ज्यादा सही।
नहीं,
फिर बाद में दूसरा बेंच आएगा,
ठीक है,
फिर कहानी शुरू हो जाएगा, इसलिए हमको
वो नहीं है, but I'm still on res judicata का,
नहीं, res judicata।
ठीक है, हम दूसरा बेंच अभी नहीं आ रहा।
अरे ऐसा आपको वो तो अभी चीफ के अलावा किसी को पता है क्या? उनको भी अभी नहीं पता होगा क्योंकि अभी कुछ डिसाइड किए नहीं। We do not know what is after all records have been received, कब रखे बताइए, आप कब करिएगा? इतना सुन लिए, आप करिएगा कब करिएगा? हम
तैयार हैं, हम कल
डेट तो हम दे देंगे, कौन सा डेट दे दें?
3 weeks for issue.
With the consent of the counsel for the parties, post this case for final disposal on 18 February. ठीक है?
Then on hearing it can be posted at the top.
फाइनल डिस्पोजल मतलब टॉप
बहुत
पर,
छोटा मैटर होता है।
फाइनल डिस्पोजल
ठीक है,
टॉप पर ही आएगा।
ठीक।
एक पेंशन मैटर है आपका, parties have not yet appeared as I'm informed in one of the case. Why they are not appearing?
I am the applicant. In that motion happened not ELC. A total of 7 people notices were sent.
Yes.
For 6 people, it has not returned. It is still in transit.
Okay.
1 person has received out of those 7 people.
Okay. So what do you want? कहाँ है बाकी, कौन किनको रिसीव हो गया?
Respondent number 10 has received the notice. 1, 2, 3, 4, 6 and 8 is in transit.
1, 2, 3, 4, 6 and 8. 5 and 7? 5 and 7 का क्या?
They have received. Earlier only they have received. Only to these people notices were served.
इन्हीं का खाली awaited.
Only 9 is awaited.
Only 9 is awaited.
9.
The last order is 8 December 2025, Para 6, wherein direction was for issuance of press notice to 7 of the respondents.
Okay. So their service report is awaited. क्या स्पीड पोस्ट से किया था क्या?
Speed post. As your lordship's direction.
अब कहाँ के लोग हैं?
सब हजारीबाग के ही हैं।
पुलिस स्टेशन को कर दो। ठीक है, स्पीड पोस्ट इतना दिन ट्रांसिट में नहीं रहता, करेक्ट? Essay number 154 of 2024. The learned counsel for the parties are present. It has been submitted that notice was issued in terms of order dated 8th of December 2025 upon respondent number 1, 2, 3, 4, 6, 8 and 10. But as per the office note, as per the office note, it is still in transit. The counsel for the appellant has submitted that in order to expedite the matter, the notice may be issued through the concerned police station. Issue notice to the aforesaid respondents to the concerned police station, for which requisites be filed within a week. Okay.
Within 10 days.
आपको पता है ना वो कितना अपोज करते हैं हर डेट में?
No,
एक हफ्ता में
no, he is in. We both are same.
Actually,
I don't know.
they are selling the same. He actually not same mode. Exactly the appellant in this case, whom Mr. Nikhil represents, I represent him in the appeal filed by Mr. Salam.
ठीक है, वो तो हम जान रहे हैं, आपका पूरा दिन का कहानी है इसमें.
And this way we have filed a stay vacating application, and that was supposed to be heard. And on their prayer for giving reply, it was adjourned, but they have not filed any reply.
आप reply क्यों नहीं file करते?
Madam, everything is there on record.
Everything अपने pocket में रखे ना?
No, that's on record, madam. I'll file it.
You have filed it.
No, I'm not file. I'll file it.
Then
I'm ready for today
then
also.
on that
paragraph,
score,
एक paragraph.
एक paragraph.
then they would have
आपका
submitted.
conduct अगर सही नहीं होगा ना तो हम vacate कर देंगे.
My lord, just.
Para 9 of the last order
Go
may be
back.
seen. He himself submitted.
Next.
That I will submit reply.
Post this case on 25th February. 25th
Some shorter date is given because this time the notice in the other
18th
case.
February.
Yes.
18th February. The interim order passed earlier shall continue till 18th February.
And if one line is indicated that the stay vacating application will be taken up or considered on the next date. So that they may be sincere on their, so far as their part is concerned.
Record सब आई गया, अब क्या stay vacation सुनेंगे?
Because I will just demonstrate so far as the
कुछ
stay
नहीं फाइनल, आप
order
लोग
is
तैयार
concerned.
हैं।
That was granted.
Stay vacating ये सब का जब when parties are there and they are not dead, the civil cases have to be heard.
Because stay has a consequence in a civil case, and that requires certain parameters, and
You
those
see-
are missing in this case that we
You
want to
see,
submit.
once the case is before me, थोड़ा time लगेगा लेकिन हो जाए. That much I can tell you.
Because the stay of is of a execution in which he is not a party. Execution is against third party. He is not before this court.
We'll see
He is not
We'll
opposing
see that we have heard you enough on this. पूरा 15-20 मिनट हम आपका argument सुन
We both are different, or this case and my case is different. The lady said, this is also there.
अच्छा कोई बात नहीं, आप आइए ना, आप लोग इसका compliance करिए, हम
No,
लोग
we
लेकर
comply
आएंगे.
it, we comply it. I'll comply it tomorrow itself. Right.
And if only one line is indicated,
One
because no, last order में last time
That
they said that we
that-
have
That
signed
will
reply to stay
always,
vacating.
that will always.
But this time they have not submitted reply.
अगला
They are
दिन में
saying.
तो इनको time भी नहीं देंगे file करने.
From supplementary list
ऐसे
orders,
सुनिए.
item
आपको
60.
मन नहीं कर रहा है फाइल करने
No,
का? इसी ground पे vacate
No, my
करना
lord,
है.
I'll-
That you
I'll
have-
shoot, my lord.
you have no objection to stay vacating.
No, I have. The stay vacating petition is defective in itself. One paragraph is there. That.
तो file तो करेंगे ना
Yes, ma'am.
objection.
I'll file.
Everything orally.
चलिए fine. Orders का
From
कितना?
supplementary orders, item 60, second appeal 39 of 2023.
Yes, madam, we have filed a litigation petition for continuation of 9 days only.
9 days delay. So in second appeal,
In second appeal.
we will hear you on minutes. You have your minutes. Rest is, there are no other defects?
No, lordship, there is no.
If I am satisfied on merits, I issue notice on limit. If I am in, इतना 9 दिन का डिले के लिए हम hearing नहीं हो तो आप बताइए.
Please, for this quick date, they use it. I am not.
AC number 39 of 20. The learned counsel for the appellant has submitted that the appeal is barred by limitation by 9 days. However, before issuing notice on point of limitation, this court wants to be satisfied as to whether there is any substantial question of law involved. Counsel for the appellant raised that the matter be posted on
2nd of February.
2nd February post on सेम ही डेट हो जाएगा. अब तो ऑर्डर ही कर दिया. होगा तो हम नोटिस करेंगे, नहीं तो फिर किस लिए नोटिस करेंगे.
From date list for orders be defect item 2, second appeal 194 of 1020.
Yes.
Last item, IE number 9673.
9633, yes.
In which leave was sought by the applicant to pursue this second appeal on behalf of appeal number 6 and 7. Paragraph 4 Millard.
Paragraph 4.
But C का वो है appellant number 6 मतलब he died prior to the judgment of decree under appeal, Lord. And as such, in the second appeal they have been arraigned. And my lord has directed because death certificate was not filed along with this IA. So on the last occasion, my lord directed to file supplementary affidavit, bringing on the record to death certificate of Siddharth. And supplementary affidavit has been filed, my lord.
It has been brought on record.
Yes.
So, the appellant number 6 now,
Yes.
this Shivlal Hajam,
Yes.
was the appellant before the court or
Yes.
was the...
Appellant. Appellant number 6. Appellant number 6, my lord, have gone to the impugned judgment. First page, my lord, will find Shivlal Hajam, sons Sunil Hajam, sons of late Aklu Hajam. So Shivlal was appellant number 6.
What is the consequence?
Consequences is, my lord, that since he died, suit cannot be because he died after pronouncement of the judgment and decree, so it could not be awaited.
After pronouncement?
Yes, yes. Can you see the date, my lord?
Yes.
19th March 2020.
IA number 9673 of 2024. दोनों का वही हाल है.
नहीं केवल एक appellant number 6
And appellant number 6 and 7 are the legal years.
the legal years who have been arraigned
That's
already arraigned.
the learned counsel for the appellant has submitted that IA number 9673 of 24 has been filed, seeking permission to pursue this second appeal on behalf of appellant number 6 and 7, who are the legal heirs and successors of Siv Lal SHIB Lal Hajam, who expired after the pronouncement of the judgment by the first appellate court. He submits that the office objection in that regard be ignored. The date of death of Shivlal Hajam is 17/8/2020. He submits that his death certificate has already been placed on record by filing a supplementary affidavit. Considering the submissions, the office defect in connection with appellant number 6 and 7 is hereby ignored. Accordingly, IA number, this is allowed, 9633 of 24 is allowed. अब
दो और आई है उसमें से डेथ हो चुका है लेकिन माइलर अगर एडमिशन पे सुनेंगे तो एडमिशन पे तो
आईए में डेथ पर तो कौन सा किसका डेथ?
ये वो ड्यूरिंग पेंडेंसी ऑफ द सेकंड अपील है फिरोजा हजाम का डेथ हुआ है लेकिन माइलर आई ट्रेन सम टाइम माइलर क्योंकि सब वकालतनामा हैज नॉट बीन फाइल्ड बाय देयर लीगल एयर्स.
This is appellant number 1 and 2.
यस.
इसका इनका वकालतनामा कहाँ है?
नहीं इनका लीगल एयर्स का फाइल हम रिकॉर्ड चेक कर रहे थे नहीं फाइल हो पाया है हम इसलिए टाइम मांग रहे थे केवल आज डिफेक्ट रिमूव हो जाएगा उसका दिए लगेगा.
और एक आईए है अपीला नंबर 3 का भी डेथ हो गया.
जी अपील नंबर 3 का भी डेथ
1, 2 and 3 तीनों का
जी
डेथ.
तीनों का सब वकालतनामा मंगवा करके फाइल कर देंगे तब माइलर इसको.
The learned counsel for the appellant has submitted that the appellant number 1, 2 and 3 have expired during the pendency of this appeal, for which a petition seeking substitution has been filed through IA number 9634 of 2024 and IA number 2728 of 2025. Is it barred by limitation?
Yes, barred by limitation.
He submits that these petitions are also barred by limitation, and accordingly a prayer has been made for condonation of delay
Yes.
and
Setting aside
abatement. let notice be issued on these two interlocutory applications to the respondents, for which requisites under speed post be filed within a period of 1 week. The counsel for the appellant has also submitted that he shall seek instructions and file wakalatnama on behalf of the legal heirs and successors of appellant number 110. ठीक है? तो एक दो डेट तो बच गया आपका?
हाँ बची डीपली हो गया
पोस्ट ऑन 18th of February. Respondents कितने हैं इसमें?
इसमें है कोई दिक्कत नहीं
ज़्यादा नहीं है, 3 ही है,
ठीक।
3 है बस, ठीक है ना? पीटर बार, सब एक ही फैमिली।
एक मतलब एक चीज गलत हो गया है 17th लिखा गया है उसका अपने नंबर 6 है सिद्धार्थ का डेट लेकिन डेट ऑफ जो डेथ सर्टिफिकेट है उसमें 16 तो 16 ही 16/8/2020
16/8/2020 लिखेंगे, ठीक है? डेट ऑफ
17 लिखा गया डीपली
चलिए, आपका कुछ है?
Interim order is still to be.
कौन सा?
Serial number 12, 183, 2022.
अभी तक अपियर नहीं हुआ था, सही?
नहीं, कोई अपियर नहीं हुआ है। इसमें नोटिस सर्विस हुआ है 1, 4 to 6, 2 and 3 रिटर्न आंसर। 2 का अगेंस्ट में कमेंट्स है कि प्राप्तकर्ता घर में नहीं रहते। मेन कॉन्टेस्टिंग रेस्पोंडेंट यही 1 and 2।
इनको सॉल्व नहीं हुआ?
नहीं, 1 का ऊपर हो गया है, सर्विस रिपोर्ट है। ट्रैक रिपोर्ट इज आल्सो देयर।
2 and 3 तो अनसर्व्ड है, लिखिए।
2 and 3।
ऐसे नंबर 183 और 2022. Counsel for the appellant is present. As per the office note, the notice has been served upon respondent number 1, 4 and 6.
1, 4 to 6, 4, 5 to 6।
1, 4 and 6 लिखा हुआ। नहीं, respondent number
4 to 6।
4 to 6.
That's right.
So far as respondent number 2 and 3 are concerned, the same has returned unserved on account of insufficient address. The counsel for the appellant prays for 2 weeks' time to take express steps for service of notice upon respondent number 2 and 3 at their present and correct address, or to file an appropriate petition seeking substituted service of notice. At this, the counsel for the appellant submits that the interim order passed by this court dated
25/11/2025
25/11/2025 be extended. Let the interim order dated 25/11/2025, the interim order dated 25/11/2025 is extended till 25th of February, post on 25th. आइए पेंडिंग। आप क्या कहें?
Serial number 21 is we have filed an I combination of delay for 1 day in FA 194 of
21
serial number. The respondents are the state party. There is no
line.
IN number 11707 of 2025.
I number 11707 of 25 in filing numbers 91. बाकी सब defect removed है?
FA number 194 of 2025.
In FA number 194
4 of 2025.
4 of 2025, counsel for the appellant has submitted that the appeal is barred by limitation of 1 day. A petition has been filed seeking convocation of relief. peruse the integrity application, delay in filing the appeal is condoned. Admit, call for records from the concerned court. Okay?
Much.
Let this order be communicated to tax. और किसी का कुछ आपका है?
Yes, madam. My lord, serial number 6 है, इसमें respondent number 6.
हाँ, क्या होगा? कहिए। क्या
My
होगा?
lord, इसमें respondent number 19 को notice हुआ था जो alive थी। हम लोग IA नंबर 3459 में पारा 10 में मेंशन किए हैं। तो लॉर्ड इस पे ऑर्डिनरी प्रोसेस से नोटिस हुआ था, अभी तक जो ऐसा जो आया नहीं है, तो थ्रू द कंसर्न पुलिस स्टेशन कर दिया जाता है।
बाकी लोग को सर्व हो गया है?
यस मिलो, सिर्फ इन्हीं का था। पच्चीस के ऑफिस नोट से रेस्पोंडेंट नंबर 10, 19 और 17 have found reported that नॉट पारा 10 देखा जाएगा तो उसमें रेस्पोंडेंट 19 नेमली शांति देवी विडो ऑफ अशोक मिश्रा ऑन इंक्वायरी it has been found that she is alive.
Essay number 609 of 2017. Counsel for the applicant has submitted that the service report of respondent number 19 has not yet been received. He submits that the notice be served to the concerned police station. Let notice upon respondent number 9 and the counsel for the applicant is directed to take steps for service of notice upon respondent number 19 by filing requisite through the concerned police station by filing requisite within a period of 1 week.
Yes, no.
किसमें नोटिस होगा? कुछ आईए में नोटिस होगा कि किसमें होगा?
आईए में होगा।
आईए नंबर किसमें होगा? आईए
3459।
इन आईए नंबर 3459। ठीक है? पक्का है ना?
Yes, no.
ये तो रेस्पोंडेंट नंबर 10 के लिए है।
रेस्पोंडेंट नंबर 19 के लिए भी इसीलिए।
अच्छा 19 के लिए। ठीक है। ओके। डेट बताइएगा। पोस्ट ऑन 11 से